Well, good morning, everyone. This is Rex Crandall, and we're going to be covering the exciting topic of court accounting today, and we'll be going through it in great detail. And you're welcome to ask questions during the class. If it seems like we have too many questions and we start falling behind in our presentation, we might defer questions till later, but that's usually not a problem. We're going to be covering a lot of material, and we're going to be working out of the Handbook for Conservators, which is the entire book is available online. This is what the cover looks like. It's about, I don't know, 80 pages or more, maybe more, I don't know. But it was put out by the Judicial Council of California Courts. The last update was 2016. It's still the current version. And we're going to be going through one segment of this book for accounting. And for those of you who are guardians or conservators, this book is a good reference source for additional information on being a conservator. So I wanted to ask, so I can get an idea of how to organize the material, if you could tell me a little bit about your case, if you're pro per or you're a law firm, and that way we can design the class around you. If we could start with Ashley Wu. You might be.
Hi, I'm Ashley. I'm a legal at a estate planning law firm.
Okay. Okay. And Grace Yao.
Hello.
Hi.
I'm a paralegal working for an
I could not hear you. Could you talk louder, please?
Do you hear me now? Hello?
Yes. Yes, if you could talk a little louder.
Okay. I'm a paralegal working for an estate and trust firm.
Okay. Great. And Janelle?
Yes, I'm a paralegal for a probate and conservatorship law firm, and
Okay.
I have no accounting experience.
Okay. And Jennifer.
Yes, I'm a estates and trust attorney. Ashley Wu is my legal assistant, and I'd like to be able to review the accounting to know what I'm looking at.
Okay, well, that's always a good sign when it makes sense. And hopefully after today, it should make sense. We're going to cover the construction and how to put the accounting together. We're going to emphasize judicial counsel forms, but since we're aiming at preparation and teaching people, the class is originally designed for pro per participants in the court process for guardians, conservatorships, and trusts. We will not be covering or emphasizing the problem areas or how things fall apart and things. We might have some examples of that, but it's basically how to prepare the accounting. How about Mary B?
Yes, I'm a paralegal and do some contract work with the law firm Elder Law, and
Okay.
that is also with that Rosanna is there, Ro, and Janelle, and I don't know if Paula's on or not. If she is, so we all work for the same attorney.
Okay. Very good. Okay. And what about Nicole Clark? What kind of case do you have going, or your interest?
Hi,
Hi.
I'm a personal representative for my brother, and he passed away last year, and my brother and I are in probate, and I don't know, he had a trust, so hopefully we won't be in probate long. I just want, in the meantime, he passed away a year ago. I had expenses, I don't know how to organize them, so.
Okay, so you're
Well,
breaking up a little bit, your microphone. From what I think you said is you're in charge of a probate or a trust and you have accounting to do, is that right?
Yes, yeah. My mother passed away last year, and my brother and I are both representatives for him. But we're in the process, and it's taken a little while, and we've had some expenses and other people chipping in and covering things, and lots of people to reimburse. And so I just want to have it organized.
Okay, good. Well, this is a good class for the one specific area of the court accounting, which you'll probably need to turn in. And welcome to the class.
Thank you.
Okay, so I got a better idea on who's in the class and what skill level we're looking for. My assistant, Tamara Brown, will be here shortly. We trade off in teaching. She covers a large segment and I cover a large segment. This court accounting applies to several different groups. Guardianships, conservatorships. It's required for probate. It's also used for trusts when a trust reports their accounting to the court. And it's also the standard that trusts report to their beneficiaries. If you are providing this service to third parties, there's no required license for court accounting. So it's basically, it's very similar to bookkeeping for private enterprises, that you don't need a license, you don't need to be a CTEC, CPA, enrolled agent, you don't need to be an attorney or an LDA, legal document assistant. One advantage of the court accounting for someone acting as a trustee, when there's no court involvement in the trust administration, at any time, if the trustee, let's say, for example, has trouble with a beneficiary, is complaining about expenses and things like that, or management of the trust, the trustee can bring the accounting before the court to get approved by the judge. And when the judge approves the accounting, because there was notice and an opportunity for everyone to object to the accounting, once the judge signs off on the accounting, it relieves the liability for personal liability and fiduciary liability for the trustee. So oftentimes when a trust is being closed, all the assets are distributed, and the trustee wants to be relieved of their duties, frequently the trustee will ask all the beneficiaries to sign a waiver and acceptance of the accounting and relief of liability. And if the beneficiaries do not, and there's a threat of litigation, or even just they don't accept the accounting, then the trustee has a right to bring the accounting before the court and get that relief of liability. The court accounting's trust, as I mentioned, is optional. For the other kinds of cases, probate, conservatorships, guardianships, it's mandatory. And so it becomes real important, and it's difficult sometimes to find someone that knows about court accounting, because I'm a CPA and an attorney, and when I was going through accounting school at San Francisco State, they never touched this particular topic at all. Didn't even know it existed at the time. And oftentimes people will hire a CPA or accounting or bookkeeping firm to do court accounting, and they absolutely have to know about it. And the reason for it is that the fiduciary, the trustee or guardian conservator, will end up sometimes paying someone to do the accounting. And then the court says, you're not even using any of the court format. We can't accept this. And then the fiduciary hires a second person to do the accounting. And the problem is the court holds the fiduciary personally liable for hiring the wrong person and paying for the same expense twice. So, and we've had problems with this where people claim to know the court accounting. It comes out from the probate code. It starts out in probate code section 1060. But it's something that either a person knows or doesn't know. And there's no real middle ground in that regard. I wanted to, we're going to get into a lot of super details on all the components, but I wanted to give you an airline view at 35,000 feet, what a computerized accounting looks like, because during the entire class, we're going to be working on judicial counsel forms, which are have a lot more detail in terms of the court information. And so this is an example of a computer generated, whether it was Excel or some other software. And there's a form that we're going to talk about at length called the GC 400 sum, meaning summary. And it's always on the cap sheet, the top sheet. And this is an example of it in an Excel. We have assets, all the income, the disbursements, ending assets, and balances. And this particular report, I call this a work of art. It covers the data in different methods, like this way, or as a property at hand, on hand at the beginning, showing all the detail of the assets. And then there's two different methods of reporting the transactions. One, in this example, is a chronologic list of all revenue, and then another one for disbursements. And after the chronological list, it goes by account name. And so it gives the judge two different ways to view the income and disbursements, by categories and by sequential. And gains on sales of stocks. Then we got disbursements. So anyway, this accounting for Ham and Egger Trust is in your material, and it's a wonderful guide on if you're trying to do it on Excel or some other software. It's a good guide to what it might look like. In the material also, we've included in the the material that's we're not going to be covering in class. We also have a little template for court accounting on an Excel spreadsheet that we make available to class members at for $50 for the template. It's not super elaborate, but it does work. Let's see what other documents we have here. Oh, okay. Another document that's in the material available for the class is what we call the handout that we non-follow along outline. And this is a collection of helpful information for you that I've assembled to act as a backup or review. It includes information on accounting from, I believe this is the Alameda County Superior Court, information on court accounting, different things. And sometimes when you're involved in court accounting, you have to find out what code section might apply. And this is a little cheat sheet that's, if you need it, it's extremely helpful. Some trusts and estates have different beneficiaries for the income, and then they'll have another beneficiary for the remainder or the principal. So when that happens, it complicates the court accounting a lot, because you have to determine which bucket every transaction goes into or comes out of, whether it's principal or income. And this is just reference. I'm not getting into it in detail. Another example of computerized court accounting. So, and then the other thing in this non-follow along handout I've included, I contacted the probate referees in the Contra Costa County Superior Court, and they gave me their checklists that the probate examiners who review all the documents that you filed, this is what they use to look over to see if you missed things. So it can be very helpful before you turn in your accounting. This one's accounting for trusts. It tells you the kinds of things that they're looking for and whether you have them. This one's accounting for conservatorships. Very helpful to try to keep your accounting from getting rejected or getting what they call tentative rulings, where you turn in your court accounting and then 10 days before the hearing, you look on the court website and you see what they call probate examiners have written as a ruling for your hearing. If you left things out, you check that website, and then you can correct things before the actual hearing. So let me see if I have other handouts that I was going to go over. We had two other items. One, I already gave you the reference on the handbook for conservators. The other, this is not in your materials. Another reference material that is quite handy at times when you're trying to look up something is called the Probate Referee Guide. And so this booklet, it's available online. Probate referees are required to appraise everything that's not cash within a probate and within a guardianship conservatorship. So sometimes if you're not sure how to report something or how it's classified, getting a reference from the probate referee, you get an idea of what the probate referee is going to do during the appraisal process. We frequently use probate referees when there's a decedent in a trust or a probate to get appraisals that we later use for income tax purposes, because the trust or estate gets a stepped up basis, so they don't usually have to pay tax on property that's sold shortly after the death of the settlor. The last form I wanted to point out in our packet of forms is a course evaluation that you would submit to the Contra Costa County Law Library and ourselves, telling how we did, and we especially look at these to find out if there's additional information or how we could have done better. And we look at all of the suggestions that people make available to us. So at this time, I'm going to bring my assistant, Tamara Brown, and she's going to teach material for a while, and then I will be back.
We're not standing today.
You want to stand?
It's just better. That's okay. Hello, all.
Hello.
Hi.
So I'm going to teach, but I've got to find where the forms start. So I'm going to start, well, welcome. I'm going to start with the inventory and appraisal, which is the beginning or what needs to happen before you even start an accounting. This is the form that has a title up top here, DE 160 or the GC 040. What is the importance or what is the purpose for using this form? What data needs to be on the form and how it will help you with your accounting when you need to complete that accounting. And I'm going to go through how this form affects or can change or can ruin actually your accounting or your attempt at trying to process the accounting. So typically you will get this form. It is completely blank. I'm showing you an example here, but the form is completely blank. It won't have, maybe I shouldn't say completely blank. It is missing pertinent information that has to do with you in your case specifically. So even though my example up top shows an attorney, if you are going to be completing this form and you are not represented by an attorney and you're just going to be completing the form itself, we will, we will go through exactly how you need, what you need to put and where you need to put it, and then how do you come up with this information. Okay, so the top part, even though it says attorney for or party without an attorney, if you were completing this form on your own, you would put your name. Of course, you won't have a state bar number. You will put your address. So, you know, your name, your address, and it wouldn't say, of course, attorney at law. So then you would go down to the telephone number and you would put your telephone number. The fax number is optional. A lot of people really don't use fax much anymore. So if you don't have a fax number, you would just leave this section blank. An email address, although it says it's optional, I will tell you the courts, if they had any questions, if they wanted to contact you, if they wanted to send you tentative rulings, they will do so typically using your email address. It's a whole lot faster, especially if you're talking about tentative rulings. Some counties, depending on which county you're in, if some counties send tentative rulings pretty, I'd say a week, maybe 10 days sometimes prior to the hearing date. It is actually a wonderful thing because it allows you the time and opportunity to correct any issues that they have brought to your attention. It could be you forgot to sign this form. If that's the case, all you do is sign it and rush it over to the courthouse, file it, and then before your hearing, it's all corrected. So by the time the judge calls your case that day of your hearing, everything will be corrected if you have the opportunity to correct it. So typically they'll send it to this email address. So even though it says it's optional, I like to state to always include your email address unless you absolutely don't have one. Well, then what would happen is, which I don't see it often, the only other option they have to get you those tentative rulings is to mail it to you, which means the delay in mail. The courts are a little bit still overloaded, and so I don't see them mailing anything to you. So you might not even know you have items to correct prior to the hearing or at the hearing until you get to the hearing, which means your case will be continued. And when it's continued, you know, it's months later. So, okay, where it says attorney for, this is only referencing, this is attorney and who is he representing. So in this case, you would put your name here. And typically we put a comma and then put pro per, you can put pro se. There's a few other words you could use, petitioner, proposed administrator, but I don't like using those words because, or actually you're an administrator at that point, you could put that. But typically you would put your name and pro per, which indicates to the court you're filing this on your own. So down here where it says the county of, it's dependent upon where your court hearing is heard. It could be Orange County, it could be Contra Costa County, it could be Solano. I mean, shoot, there's so many different counties. So you will make sure you fill in, what county your courthouse is and the address. Most of the time, the branch name, if there's not a specific courthouse or something, typically what we will do there is we will put probate department. So unless you know the branch name for the courthouse, I would just put the probate department. Okay, estate of. Now, there's going to be a few different ways. So estate of typically means who is the party that, one is the decedent, or two is the conservatee, or three is the minor. So you would only be filling out this forms if you have one of these three cases. In this case, we're going to use the example of Jeannie Lowry. Jeannie Lowry is our conservatee. So that means you are the conservator. Now, you will also complete this if you're the administrator. And so your Jeannie has passed away. And so you are taking care of her estate. Then it would be Jeannie Lowry and you would mark decedent, not conservatee. Again, if it was a guardianship of a minor, you would put this name right here and you would only mark the box minor. Okay, we're going to continue down the form. Sorry, the mouse is going the wrong direction. And your inventory and appraisal, you have several boxes here that you can decide to mark. One would be a partial. Now, what would be the purpose or why would you mark this a partial? Sorry, I'm getting distracted by a few people joining in questions. So what box would you mark when you were completing this? A partial would mean, say for instance, that you have marshaled your assets, you know what you have, but there are a few questions that you possibly think, for instance, somebody has told you that the decedent or the conservatee owns property in another state. And so you're still trying to figure out, is it really an asset that you should be including on your inventory and appraisal? It could mean that you are still trying to get information from annuities, or you're still trying to figure out some accounts. You know they're out there and you know they belong to the person but you're just not sure like how they're titled, should they go on the inventory and appraisal, so on and so forth, you would mark this as a final. Partial. And if you're doing several, so like the first one would be a partial, that would indicate to the court that your inventory and appraisal is not done. It's not ready. It's not complete. So they're going to be looking for like a second one that will either say it's a final or it could be for other reasons, which we'll get into over here. The next one you can mark is a corrected. So say for instance, you turned one in, you marked it final, and you found out later you had assets. Oh, geez, I just found an annuity, or I just found real property, or I just found oil rights, or I just found, let's say, a 5-carat diamond ring, or whatever it is that you know is important and that your beneficiaries are going to be looking for and possibly tell you you're a bad person because you haven't included it, which means you actually took it, even though you didn't take it, you just didn't know about it. You could mark this as a corrected. Most of the time, you will be marking it as a final. Final means this is it. Here you go. It's all I have. I've done everything I could. I've looked all over. I've taken my time. I've gone through the mail. I've done everything I could, and I truly believe it's a final. Then we have a reappraisal for sale. So typically this is only for a decedent's estate. And what does that mean? So in some cases, the courts, if you have a decedent and you are the administrator, the courts will only give you limited authority. Limited authority means you need the court approval for basically almost everything you do. In the case of, say, for instance, you have a property you want to sell, and you're going to ask the court for approval. As we go through this, you will see that most of the time, this inventory and appraisal is going to be at the day of death if you have a decedent, or it could be a day of appointment for these two. The only time you would use this reappraisal for sale is if you really had a decedent and you wanted to sell the property. Because as we go through, you will see that the first inventory and appraisal that you're going to get, or the one you're going to turn in, if there's only one, will be what is the value at the date of death. So say for instance, you have a conservatorship. Let's use this one. So let's pretend this person right here is a decedent, and we see that they passed away on March 8th, 2012. Now we're in 2022, and your probate referee has already valued the property as of the date of death on a house. And now in 2022, you need to sell the house, and because the heirs have decided they want the cash, not the house, and you'll go through all that. You would fill out another one of these and only mark it reappraisal for sale, and then the probate referee would then reappraise the property as of today's date, and that will tell the court what is the property worth, so that when you turn in a sales contract to the court and the sale will happen during a court hearing, the judge knows what's the value of the property, because he has the reappraisal for sale. And so he knows that, say for instance, the property came in at 700,000 and the only sales offer you come up with is maybe 400,000. He's probably not going to sell that house during that court hearing. So that's the only reason why this box would be marked. You can do a supplemental. A supplemental can, I actually don't like really using the supplemental much. I would use a corrected instead of a supplemental, or I would do the first one a partial and then the second one a final. I just wouldn't use supplemental. Now, the property tax certificate, that's completely different. That has to do with it when you're selling property. Now we will move over to your case number. Here is where you'd indicate what is the case number that was given to you. And this case number will follow through on page 2 and all the other forms. Again, this date I went over earlier, but this date is the date of death of the decedent. This has importance on a few factors. It could not only be, again, the date of death of the decedent, but it can also be when were you appointed conservator, and the importance of this date. So let's start with the decedent. So the decedent passed away on this date. This is the date that tells the probate referee, what date do I value what everything is worth? So say, for instance, which we'll get through the non-cash assets. Say you have a house. It tells the probate referee that he has to go back and figure out what the value is as of 2012. Right? That's a long time ago, 10 years. If I have to figure out, oh man, how much was the house worth 10 years ago? Oh, goodness. You know, so it really tells them when they give a value, what was the date of that value? Now, it could be that this says March 8th, 2022. So it's not as an extensive of trying to figure out the value. It's a little bit easier for them. Now, as far as if it's a conservatee, and this is the date of appointment, this date of appointment means that is the day you are responsible for every single asset, whether it's cash, non-cash, a combination of cash and non-cash. This is the date that tells the court, when did you become responsible? And so from this date forward, you are going to have to account, you are going to have to record, you're going to have to be responsible for everything that happens from this date. So that's why this date is really important, that you have the proper date. Because say, for instance, let me just give you an example as we go through this later on. Say, for instance, you put the wrong date. So say you accidentally, instead of March, thought it was February 8th. And so February 8th, you're a conservator. February 8th is the day you put here. Although the court will probably correct it because they know when you got appointed. But say you put February 8th. And so you're saying you're responsible from February 8th going forward. Well, really you weren't. And say the conservatee spent, I don't know, $10,000 and they went off and they gambled at the casino. The heirs are going to say, what? 10,000? No, you're not allowed to give the conservatee $10,000 to go to Reno to just play. And now they want you to reimburse that $10,000 because you shouldn't have done it. You would then have to turn around and fight and say, no, wait. I wasn't even responsible then. I shouldn't have to pay that back. I had no control of whether the conservatee took the $10,000 and went to Reno. And they'll say, but it says that you started your appointment that day. So just be careful that you put the proper day, because this day means when were you responsible, if it is with a conservatee or a minor. Again, the date is the date of death if it's a decedent. Okay, So now we're going to move down to the little bit more difficult part of this, which is the appraisals themselves. So number one says the total appraisal by the representative, the guardian, or the conservator. The representative is for a decedent. That typically means the administrator, or it could be the executor. It just has to do with the decedent. Guardian is for a minor, conservator is for a conservatee. So it says you will complete attachment 1. Now, let's just look here before I switch to the attachment 1 and show you what it is. The second attachment that we will have as part of this appraisal will be the total appraisal by the referee. That means you are not responsible for this, but we'll go forward and we'll start with attachment 1. So what goes on attachment 1, and what are you as the representative, guardian, or conservator responsible for? Okay, I'm going to switch pages so I don't want to I think that's attachment 1. So here we go. So attachment 1 will be completely blank, and it has a different number. So this is the DE 161 or GC 041. Now, just so it doesn't confuse you, I'm going to give you a little explanation on why does the form have 2 different numbers. The DE stands for decedent's estate. So remember, and I'm going to switch back over here, decedent's estate would be if you were completing it for a decedent. And then GC stands for guardian conservator. So again, if you completed this and you marked either one of these boxes, this is the form they would consider that would go with it. So that's why it has 2 different names. It's either for a decedent's estate or a guardianship conservatorship. Okay, so this will be blank. You will want to put the name of the person, I'm going to switch screens again, that you put here. So who are you responsible for? Let's just say, well, you're really not responsible for a decedent anymore, but you're responsible for their estate. But you are responsible for a conservatee or a minor. So let's go back to completing the form. Oh, sorry. And you will put your case number. That's from the front of the form. Okay. This attachment will not have this number 1, so you would put the number 1 there because it is going to be a blank form. And you will indicate how many pages you believe or you will have or turned in that's appraisal number 1. Okay, so I'm going to give you some examples of what is going to be, what are you responsible for reporting and providing the value of, and then what you are not. So on appraisal 1, you must consider that the only thing you are responsible for is cash and anything that's cash equivalent. Again, a cash is not a ring, is not a house, it's not a car, it's not so many other things, which I will show you, which will go on the other attachment. Cash is cash. So I'm going to give you some examples. You may not have all of these examples. And again, they're just examples to give you an idea of how you would report if you had these assets. So the first one says cash found. So in this case, I've indicated, and if you know, or if you've been around older people, love my older people, but if you're around older people, they always have to have cash, as opposed to maybe my generation or the younger generation, we hate carrying cash. It's our phone, it's the cash apps, it's maybe, you know, a ATM card, it's something, but we never have cash. I mean, I hardly, I have to scrounge to try, if I get to a parking meter, I'm in trouble because I have to, but now they do the ATM cards. But anyway, so cash, the older people, they love and always have cash. So a lot of times, I'll use my dad in the example. He's 88 and I help care for him and he always has cash. So I'm indicating that the cash can be found in their wallet, it can be found in an envelope, it can be found in one of their drawers, it can be found anywhere. Could be in the car actually, if you think about it, but I don't think they really keep it in the car much. But cash found, and then I've indicated here where. You don't necessarily have to indicate where the cash was found. More or less that there is cash. And in this case, I would put Conservators residence, and sometimes I'd like to be very careful. Here's another reason why I don't like using this address. This is public information, meaning anybody can get a copy of this document. And I kind of want to reserve stating where the conservative lives, unless it's like a facility where somebody couldn't go over and possibly take advantage. Knowing that somebody's conserved tells somebody who is maybe not the best person that this person, you know, might not think properly, or they might be frail or brittle or something like that. And it just kind of leaves them open to be vulnerable. So I don't know that I always, I would put the residence or the address for the conservatee. I think I would just put cash found at Conservators residence. Now, over here, you're going to indicate how much cash. So in this case, I found $250. You don't have to state if it's in bills. Maybe it is a jar of coins. And I always laugh because my father loves keeping old coffee cans of pennies or nickels or even change. And I thought, oh Lord, if I had to count all that, I'm in trouble. But anyway, you would indicate the amount of cash. Now, the second thing, balance in the checking account. Here's another thing. Again, this is information anybody can get a hold of. Please, 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 for the sake of your conservatee or your minor, do not indicate the entire account number. It is not necessary. I only indicate the last 4 digits, or in this case, they indicated 5. I do not want anybody else to be able to possibly know my conservatee's account number. Especially the fact that I'm telling how much is in the account. You just don't want to do that, hun. Only the last 4 digits. The courts know people do this. And in fact, if you would accidentally put the entire account number, you're probably going to get a pretty stern tentative ruling that says that you have taken an oath to keep the conservatee's information private and confidential, and now you've not done that, and you will get a pretty stern warning that now you better stop what you're doing, figure out a different way of only reporting and not including the full account number. In this case, it's also stated balance in the checking account. I like to state where the checking account is, but I see a lot of times it is not done that way, and it's not wrong if you don't state where the account is. I don't know that I always would include an address. For instance, if it was Bank of America, they're all over the doggone place and they move all the time. So I probably would only put balance in the checking account, the number, Wells Fargo, Bank of America, something like that. And leave it like that. I wouldn't indicate the address unless you know it and want to include it. That's perfectly fine. Now we're going to get to this number over here. There's a few things that are very, very important, and I see a lot of mistakes made so I get a lot of times where a conservator has turned in an accounting, it was wrong, the court stated it's wrong, you have to go back, they won't accept it. You can't figure out how the accounting's wrong, where you've looked everywhere, you've written down everything you needed for the accounting, and you still can't figure out what happened or why it's wrong. Well, here's one of the first things I will do when I am hired to review an accounting or to start an accounting, or say I was doing a brand new accounting on my own for somebody. The first thing I'm going to do is look at the bank statement, because that's how you're going to start. I will then go back, and sorry, I'm going to switch screens again, to this day of appointment. And I'm going to look at what was the balance in the account on the day of appointment. Now, bank statements didn't used to have this where they had a daily running balance on the right side of a bank statement. They only used to report it at the beginning and end, say on the top of the bank statement. Well, that has changed a great deal now for this reason, or if, let's say, you have a bank that doesn't do that, you literally have to go into the bank and say, okay, what was the balance on the day I was appointed? Because that's all you're responsible for. So don't take a bank statement that runs from March 1st, 2012 and put the balance on, I'm sorry, I'm going to switch screens again. The balance right here, don't put this balance amount that was the balance on March 1st. You weren't responsible March 1st. You're responsible on March 8th. So you need to figure out what was the balance on the day you were appointed or the day the decedent passed away. And this is the number one mistake I always find. I'm like, oh, okay, I see why you can't balance. You gave the on your inventory and appraisal, you gave the balance on the day of the bank, the beginning of the statement, and not actually the day that you were appointed. So that same thing falls through on my next example, which is the savings account. Again, this just says balance in the savings account, only lists the last few digits, where and what was the balance. Same idea as up here. Do not give the balance on the day of the statement or the beginning date of the statement. You want to make sure you know the balance as of the day you were appointed or the decedent passed away. And I'm sorry, I get to move a fan. It keeps blowing my hair in my face, which is making my nose keep itching. Sorry about that. So again, this will be the balance on the day that you were appointed or the day the decedent passed away. Okay. In some cases, you may only have these 3 items. You may only have 2 items, right? Don't think that you have to have all these items or search for all these items. That is not necessary. You're only going to report what you have. Okay, in this example, you may also have a CD. In this case, I listed a CD, what was kind of the account number, the bank that's holding it, or the names. Now, a lot of times, this is a lot of information you might not know. Don't stress and not do the inventory and appraisal because you don't know these tiny details. They're not really all that important. I would just indicate CD, account number, balance, or CD account number where, and then the balance. Okay, let's move down. So in this example, I always laugh because in this example, they kind of need to be updated for the fact that most people don't receive pension checks anymore. It's direct deposit or some other form of payment. So, but this is taken into account a little bit of the, or maybe they still get a check because the older people don't like the direct deposit because they don't get to see it, or they want to cash it, or anything of that case. So in this case, you have, I open the mail, and in the, or say for instance, a lot of times for like conservatives, maybe you have, they have mail on the table they haven't opened, or mail on the kitchen counter, or mail somewhere that they haven't opened yet. So you end up opening it just to look to see, to make sure what assets you have and things like that. In this case, or in this example, we found an uncashed check from the pension plan. When is it dated? It's payable to the conservatee. And what was the amount of the check? So basically, I'm telling the courts, I'm going to be depositing this amount into the account. Here's another example of Social Security. And what's the amount? And then you have dividend checks. So if you will know, with a mutual fund, you can either be paid the dividends, or you would or they would reinvest them or buy more stocks or increase stocks or something like that. So in this case, they sent the conservatee a dividend check. It's dated, and here's the amount of the check. So now we're going to the bottom of the form. And what you need to do is, some forms have total assets here, some don't. So I would type in total cash assets attachment 1, because I know this is my attachment 1. And I will put, what is my total? So this total here is the total of all of my cash assets. Now, I will take this total, and now I'm going to switch forms back on you, and I am going to put that total right here. And that's going to tell them right off the top that I have cash or cash equivalent assets of $57,844. Are there any questions before I move to the second attachment? No? Awesome. Okay, so now we're going to move to the attachment 2, which is for the probate referee. And attachment 2 is going to include every asset that the conservatee, the decedent, or the minor has that is non-cash. So again, same form. Sorry, he has the mouse going, switching screens on the opposite side. So the same form, you will put the state of and the case number. And here you will indicate this is attachment 2. So the courts, the probate referee, the court clerks, the probate examiners, everybody knows attachment 1 to us who work in the field every single day. Attachment 1 is cash, attachment 2 is non-cash. Immediately that triggers, you know, so many things. The courts kind of, and the difference, why the difference? The courts kind of take the cash and they say, what's the vulnerability? What can disappear real quick? And as you know, cash, it flies out the window or it disappears all the time. I don't know how, and I haven't figured it out because I want it to disappear and come my direction. Well, the proper way, but it does, I don't know what happens. But anyway, cash always seems to disappear. And so the courts want to make sure that they're watching that cash number and kind of making sure stuff is not disappearing. And you'll see as we get into the accounting, like, how would they know? Well, they're really going to know. And so will all your heirs and decedents, because they're watching to see that the cash doesn't disappear. With your non-cash assets, it's a little bit more difficult. And you'll see as we go through why. So you would mark this as attachment 2. Your pages, here we have 1 and 1. You are going to have start with putting your description. And Mary B, I see your comment, and Rex, I think, will run in and answer as soon as he gets to the computer. So in here, I am going to state that real property, so house, condo, mobile home, it can be whatever it is. And we will go through how. So I'm going to state real property in the city of Newport Beach, County of Orange, State of California. I will tell you that you need to be a little bit careful when completing this, and you need to realize that when you are completing the non-cash assets, you can only put real property that is in the state of California. So you say, well, wait a minute, I have property in Texas and they also have property in Florida. What do I do with it? That has to be a totally different probate in that state. California has no control jurisdiction or cannot even look at, consider, handle any property that is not in the state of California. Okay, so that's the reason what city it's in. What I'm trying to do here is the probate referee, if you could only imagine, they've been doing this for many years, but imagine like me just sending you a property address and go, hey, what's the value of this house? They're like, well, wait a minute, I don't know, I need a lot more information. So we try to provide as much information as we can to them so that they can look it up and have details. Like, say, for instance, you will see here that I took the APN or the legal description of the property. You may not know that. You may not know how to find that. You may not just have the ability to have this information. So if that was the case, you would only put real property in the city of Newport Beach. County, you would be able to figure out County of Orange, State of California, commonly known as, and then put the address. So don't feel stressed or don't feel, oh my God, I can't turn this in because I don't have the legal description of the property. I don't even know how to get it, or, you know, where I would go to look at for it or anything like that. Please don't stress. Just give as much detail as you know. And if the probate referee still has questions when he gets it, or she, when they get it and they don't know kind of what you're talking about, they'll call you and tell you. So don't stress about having an entire legal description here. So, okay, so we're gonna continue forward. This property is commonly known as, and giving the address. And then this even has the APN number. Again, you may not know the APN number. For a lot of people, that's really hard to figure out. For someone like me who can run deeds, or I'll get online and I'll look up the property tax statement. I'll go on the county assessor's website and I'll do a search of the property address, and then I can grab the APN number. As a pro-per or as a person, you may not know how to get this information. Don't worry about it. Just complete it the best you can. So you will notice in the appraised value section, I've left it blank. That is because you as the preparer cannot value this property. You must leave it blank because the probate referee will fill in the value. Okay, I'm gonna move on. In this case, we also have a vacation home. So there is indication there's a vacation home. It's in the city of Palm Springs, county of Riverdale, state of California. That might be all you know, commonly known as, but that might be all you know. Again, don't stress about the legal description or the APN. Just give as much information as you have. And again, you will leave the value blank. Now, I've also indicated there's furniture and fixtures where the property address. Typically, I just state furniture and fixtures. I don't state where those are. Again, I don't like giving the Conservators address, although it's up here. I just don't put it in. Furniture and fixtures. So let's talk about this a little bit because it can be a little bit confusing. If you go into a decedent's estate or even a conservatee, and they're an older person, and say for instance that you look in the house and there looks like there's really old furniture or antiques, or maybe a sofa that was handmade or specific made. Oh, so I had a case where the decedent was extremely tall, and so they had furniture specifically made for them, for their legs, the height, the length of the sofa. So that wasn't just a regular everyday sofa that you could go out and buy. It was a custom made piece for a taller person. Now, in that case where it's not a regular piece of furniture, I would probably list it separate. And here's the reason why. Typically, furniture and furnishings really have a very small value. They typically will take how big is the house. Is the house a 2-bedroom as opposed to a 6-bedroom? Is you know, and they take stuff like that by reading and understanding this property address. So if you're in a 2-bedroom house, you're definitely not going to have as much furniture as a 6-bedroom house, right? So the furniture is typically only a small value. I typically see it at 500 for all of the furniture in the house. Again, if there was a specific thing, china cabinet, or let's say rugs, Persian rugs, or anything of that nature, I would list it separately so that they can consider the value separately. Okay, I'm gonna move down to shares in a mutual fund. This will be something that can be a tiny bit complicated because, okay, so you have a conservatee, you're going, okay, I'm opening our mail. I see this is a mutual fund or annuities. How the heck do I know how many shares she has? Well, you're going to have to call the broker. You're going to have to call the mutual fund customer service. And you're going to have to ask the question on the day of my appointment, which was what date? March 8th, 2012. How many shares? I'm on the wrong, here we go. How many shares of this, how many shares did this person own? Now, again, remember, you're going to say, well, what difference does it make if I use the shares on March 1st or March 31st when the statement comes? That's because, again, you have those dividends that pay out. What happens if you state the shares were 1425 when they really were only 1400? But the dividends that paid out gave 25 shares on March 31st. Well, in your accounting, you'd have to adjust for that. But if you've already listed them as of the day of your appointment, you're never going to get your accounting to balance. Just won't happen. And you're going to have to pay somebody else, say, for instance, like me, to sit and figure out why you can't balance. Or you're going to have to tell the court, I just can't balance, and you're going to have to just charge me back for, because I can't figure out the dollar amount. You never want to get into that situation. So careful that you state how many shares on the day of appointment. Okay. Also on this example, there was a seven 100 US savings bonds when they were issued. I think this would be a hard one for me to figure out. Like, I don't even think I know what a savings bond looks like, much less to be able to tell it's a savings bond, but maybe. So this one scares me. I'm always looking on, how do I know what it is? But do your best here on that one. Okay. So my last example, I've indicated a diamond wedding ring, and I indicate it's 2 carats. Now, some would say, why is that important? It's very important, believe it or not. So, and this is also a hard one for me also. I'm not a diamond girl. I'm one of those that they're really not all that important to me. So I would have a huge, difficult challenge selling a 2 carat from a 1 carat from even a 3 carat. Now, if you got to 4, I'd say, oh, that looks a lot better, bigger than a 2, but I really wouldn't know the difference. And why is this important? So you're sending this inventory and appraisal off to the heirs, the beneficiaries. Say, for instance, you have, so you have a conservatee and her children all live in Florida or Nebraska or somewhere, New York or anywhere else. They know what mom has, right? That's mom. And so if you go off and say, oh, it's a 1 carat wedding ring, let's just say that, and all the kids know that dad bought mom a 4 carat ring, guess who's going to come to you real quick? Guess who's going to petition the court and say, something's wrong, something was traded, that really wasn't her ring? Because they're going to think, you took your 1 carat, you traded it with mom's 4, or something of that nature. So it's important just to indicate, so there's no surprises, there's no thinking that maybe what you're doing is wrong, or you're trying to be scrupulous or anything like that. I always like to indicate this is a very important thing, believe it or not. And it might not be a diamond, it might be a ruby, it could be earrings, it could be a watch, it could be a tennis bracelet, it could be you know, anything like that. I would always indicate, and the more you are upfront and the more you just pack the information on here, the less it looks like you're trying to hide something. And I see so many cases every single day where the heirs or beneficiaries think you're trying to hide something, and sometimes they are, sometimes they aren't. So I'd really indicate all you can here. Okay, so those are the examples we have given. You may have many more. You could have a horse. You could have, let's say, a goat. You could have, although, let's say, for instance, somebody would say she has 20 cats. Well, cats really don't have a value like a horse or a goat or another animal. So I don't think I would list that, or dogs or things like that in there. But if they do have like horse animals, stuff like that, I would indicate here. And so your form, again, could be one line. They only have a house. It could be many more lines, and it may not include the examples I've given. You could have completely different examples. But again, remember, on 2, anything that's non-cash. So if you think about it, you can tell the difference between cash and non-cash assets. And I think even if you accidentally put something on here, let's say you didn't know something was cash and you put it here, I think the probate referee would tell you, hey, you got to revise this. That's a cash asset. I don't give the value, or something, some indication would be given to you that it needs to be corrected before they even complete it. Okay, down at the bottom, you will put on your form total non-cash. And again, see this blank because the probate referee will complete this. Okay. Any questions? Oh, okay, I'm ready to move on. So now I'm going to go back to the inventory and appraisal form. So how this all works. Okay, you are going to complete, let's say we're going to go complete the rest of the form. You are going to complete the rest of the form, and I will show you how, but you are going to complete the rest of the form. And so you will have this inventory appraisal. It's 2 pages. You will have this, you will have your attachment 1, you will have your attachment 2, and you will send the entire package to the probate referee. So I'm going to give you the example. What if you don't have a probate referee and you didn't have any non-cash assets? So say, for instance, you only had cash in a bank account. Well, if that's the case, then you won't complete an attachment 2. You won't be sending it off to a probate referee. And basically you'd be done at this point. You could turn it in or file it with the court. So it's not necessarily. Now, I can switch that around and say, what if there is absolutely no cash? They just didn't have any cash whatsoever, and you only had real property. If that's the case, your thing right here would look blank until it comes back from the probate referee. Now, what happens when you send it to a probate referee? A probate referee is going to give values on the attachment 2. Oh, that's not attachment 2. He's going to fill in these values. So when you get it back, this will have $1 million maybe here. This will have $2 million here. And then you will have a total at the very bottom. And they will take that total and they will put it right here in this space right here. And they will total your cash, your non-cash, and they will put a total right here. So when you get it back, this entire section would be completed for you. Okay, I'm going to move on down the form. So we need to complete the rest of it. This is the declaration. And what is it saying? Attachment 1 Remember, attachment 1 is the cash. Attachment 2, non-cash. They together with all prior inventories, maybe you didn't have any priors, contain a true and statement of, and again, you will mark all if it's the final or a corrected or a reappraisal, or you will mark the box a portion if you're only doing a partial. Of the estate that has come to my knowledge and possession, including all money and all just claims the estate has against me, I have truly, honestly, and impartially appraised to the best of my ability each item that's set forth. And look, you're only signing that you're responsible for attachment 1. So you're not saying everything that the probate referee valued, you appraised. You're only saying on attachment 1, which is cash. So number 4, if you only had cash assets, you would mark the box a probate referee is not required. If you have non-cash assets, so I'm gonna slide in an example. You have non-cash assets. You look at your order, which is the DE 140. That's the order that will provide where the probate referee's name was provided to you. It will be at the very bottom left corner, last line before the judge dates and sign. It will have a place, and typically it's a stamp. Sometimes it might be a handwritten name in. Sometimes they provide you with the address and phone number of that probate referee. Sometimes they don't, where I have to take the probate referee's name and look it up on the internet to try and find his address or her address, or phone number or email address. You cannot email. The probate referees do not accept you to email this form to them. You have to send it in the mail. So that's where you would. So say, for instance, you found a non-cash asset and you were never given a probate referee. You've got to go back to court, get your order revised or a new order done, get a probate referee, and your case is going to continue a whole lot longer, especially. So let me give it to you. A decedent's estate. Say you're the administrator. I will tell you, you're going to get a lot of phone calls, and you're going to get them often. The main question will be, when am I getting my money? Where's my money? I want my money. I need my money. I have this situation. I have that situation. I need my money. When's my money? Where's my money? And you will hear that a million times. It just happens. The longer you extend your case, or the longer you take to complete these forms, or the longer you take to get your probate through, the madder these heirs and beneficiaries are. And if they truly feel you are taking too long, you are not doing your job, you are not following through, you are not trying to get them their money, they will petition the court and have you removed. And I see it every day. So make sure that if you even think that you have any non-cash assets, that you ask for a probate referee. Because, and typically I ask for a probate referee even if I don't need one. Because say you're assigned a probate referee, So you get an order, your DE 140. It has the probate referee's name on it. And then I find out I don't have any non-cash assets. Well, then I don't use them. I don't contact them. I don't send them anything. And okay, so what? I have a probate referee, but I have no non-cash assets. In that case, I would complete attachment 2 and I would say 0 non-cash assets and I would turn it in and the court would go, okay. Because the other thing is the court may later on, when you turn this in, go, okay, I gave you a probate referee, but you left this blank. So why? Did you not send it to him? Did you not get it back? So they may have questions. If that was the case, I would put 0 here and put 0 on the attachment 2 and just indicate, sorry, I thought I needed a probate referee, but I really didn't. Now, if the case is that you do need a probate referee, you would mark this box. And it says by order of the court dated. Again, that's the DE 140. And you will put the date the judge signed that order and stated that you needed the probate referee. A lot of times I've seen that this box is just marked and the date isn't specifically filled in. You're not going to have this rejected if you don't put that date. You will have it rejected if you don't mark either of these 2 boxes. So either you don't need a probate referee or you do need a probate referee. So you must mark one of these 2 boxes. The property tax statement. Now, again, which one would I mark? Here's the difference. The decedent, in this case, didn't own any real property. Or B, I've satisfied because of the, and I've done a change of ownership. This would really only be for a decedent's estate. So what happens in a decedent's estate, you only have a certain amount of days that you're supposed to notify the assessor, the county assessor, where real property is located, that there has been a change in ownership. The change of ownership, but you're going to think, okay, well, it's just a decedent and they still own the property. No, it's really who's going to be responsible for that property. So you would turn in a change of ownership to state, I now am going to be responsible for the property taxes, payments, or I now am going to be responsible for possibly selling that property, something of that. Otherwise, if you don't have a decedent's estate and you're only a conservator or a guardian, you wouldn't complete this at all. Okay, this now here is I declare under penalty and perjury, all the information is true. It must be dated. You would indicate your name here and you will sign it. The important thing they state is, and I have put this in here, you do not sign this form prior to receiving this back from the probate referee. How are you going to declare under penalty of perjury that this information is correct if you don't even know what the information is that comes back from the probate referee? So technically, and I don't mean this in a bad way, but you're lying if you sign this form right here. So don't sign the form yet. Wait till it comes back from the probate referee. Or if you don't have a probate referee, you would sign it, date it, and file it with the court. Okay, sliding down. We're almost done with the form. Statement of bond. In a lot of cases, if you're a conservator, the conservatee has a lot of cash. And okay, there's 2 different ways though. You could be conservator of the person, or conservator of the estate, or conservator of the person and the estate, which just means, okay, so conservatee conservator of the person means just as it is. That's more for medical purposes, that you can make medical decisions. You're entitled to no medical information, which passes through like the HIPAA laws and stuff like that. You're able to say whether they should get married, and there's a few other things with conservator of the person. If you're conservator of only the estate, it means you only handle their money. And then you could be the conservator of the person and the estate. So typically a bond requirement will only be if you control money, or a bond also would be, let's say, if on a decedent's estate, if you're an administrator and you're out of the state of California, which means the courts really don't have much jurisdiction over you because you live in another state. But then they do kind of have jurisdiction because you're handling something in California, they will require a bond. So, but then you have the trouble, which I just kind of went through with a bunch of cases last week, that a pro per cannot get a pro per for a conservator cannot get a bond, or it's very difficult without an attorney. So if you're pro per, you want to do a you want to be a conservator of finances, the court requires a bond, you won't be able to go pro per. You're going to have to get an attorney, and then they would fill out this form. So there's little tricks about that also. Anyway, you're either going to mark the bond was waived. That's typically only in a decedent's estate, where the beneficiaries can say, oh, that's my brother, he's handling the account, I trust him, we don't need a bond. And or things of that. With a conservatorship or a guardianship, can't be waived. So a bond, or you're going to mark this box, number 7, bond is filed in the amount. Typically, the bonds, I typically see them at 20,000. And again, that's standard, but it could be much more. What they do is they look at all the cash. So I'm gonna give an example, and I'm gonna have somebody answer, so be prepared to unmute if you're muted. So I'm gonna give the example. So the court, when I got my appointment, the court ordered a bond be filed in the amount of 20,000. Okay, so I do now have a bond, 20,000. I got that before I got my letters. So my bond is $20,000. Now, I'm going to slide up the screen. I've indicated I have cash of $57,844.59. On this form, would I indicate sufficient or insufficient for my bond? Come on, somebody's got to answer.
Insufficient?
Insufficient, correct. Because my bond needs to cover the entire amount of my cash. Now, what's going to happen is the bond needs to cover this full amount so that if it disappears, it can be replaced. So in this case, I would mark this box insufficient. That doesn't mean you've done something wrong, or that doesn't mean, oh my God, you know, what's the court going to say now? Or, you know, don't be scared of that. That just means when it's turned in, a court can decide, do I call him back and tell him I want the bond increase? Do I, you know, there's a few things that could go on, and you really wouldn't know this until like your next hearing anyway, because believe me, the courts don't have time to, the minute you turn in your inventory and appraisal, see if you've marked the box and your bond is sufficient or not. They just don't have the time for that. And you really, really will not get you won't get that. Like, oh my God, are they gonna call me tomorrow and tell me, I gotta increase my bond? No, it's not gonna happen like that. But you do want to be honest and say, no, you're right. I don't have a sufficient amount of bond, and you will just mark this box. Now, the other thing would be receipts. You would mark this box if you were a guardian of a minor. And the reason why you're the guardian of a minor is the minor inherited property. And as we know, if a minor is under the age of 18, they're not allowed to inherit more than, I think it's $5,000. And if they do, they need a guardian, and the money has to be placed into a blocked account at the bank. The blocked account means it cannot be touched for any reason whatsoever unless an order is given from the court. And when the minor turns the age of 18, they take their ID into the bank, show the bank their ID and that they are 18, and they are allowed to then control that bank account. They can take the blocked off the bank account. More than likely, I think what happens now with the banks is they force you to close the blocked account, move the money to an unblocked account, and then the minor can use it. Well, the minor is no longer a minor, right? He's 18 or she. And so they can use it at their leisure. So again, it's going to be dependent which box you're going to mark. Typically, you're only marking the either of these two. Either the bond was waived for whatever reason and you would know that, or you do have a bond and you would list the amount of your bond. Okay, and then we have the date down here. Now, it says printer type your name. This is going to be, so my example here, because you're wondering why is the name different than this? This was the attorney in this example. So the attorney, if you had one, would actually sign there, but they would complete this form for you. So if it's only you completing this form, you will put your name down here and you are going to sign this. Okay, we're front page. We're going to page 2. Very short part. You will put, again, the name of the estate up here, whether it's a decedent, conservatee, or a minor. You will put the case number. All of this is going to be completed by a probate referee. Again, if you don't have one, this stays blank. Otherwise, the probate referee puts how much he's charging, puts if he has any expenses, which means a probate referee gets to be reimbursed mileage, depending on how far away it is, toll, maybe if he had any other expenses, he would put she would put their expenses here, and then they're going to give a total right here and indicate to the court how much they've charged you for completing this for you. As you will see, they must also declare under penalty of perjury that this information is true and correct. They have the same thing. They have truly, honestly, and impartially appraised to the best of their ability items on attachment 2. They will print their name, sign their name, they will date it, and then they will send it back to you. So one of the things when you get it back, what should you do just to cross-check, just to make sure, just so it's not rejected, just so you know it's all correct? I kind of look at them, glance, make sure he's filled it out, make sure he or she has dated it, make sure they've printed their name, make sure they've signed. Then I make sure they have followed through and put the total here. Occasionally, I've gotten them back where the probate referee put their total here, but they didn't total it at the bottom. So I add the total on. And then I go back and sign date, and you're ready to turn this into the court, file it. And this is your inventory and appraisal. Now, you're thinking, okay, well, what was the purpose of all of this? The purpose of all of this is these exact numbers start your accounting. And so Rex will show you as he goes through the accounting portion that these numbers, these exact numbers transfer and become your beginning balances. If these numbers are wrong for any reason whatsoever, you either need to do a corrected, because maybe you typed the wrong, you had a typo and this said 5684459 and you filed it. But then you go to your accounting, you go to start and you're off, you're not balanced, and you go, oh God, I had a typo. You're gonna have to turn in a corrected inventory and appraisal. You cannot. So say for instance, here's the other thing that I get all the time and I see what happens. Say for instance, you have that your number here is 57,844, right? And you look at the bank statement and you go, oh dear goodness, it's 58,844.59. I had a typo. So I'm just going to start my accounting with 58,844.59. Guess what's going to happen? The examiners, the judge, they're going to see it and go, that doesn't match, something's wrong. And then they're going to make you do a corrected inventory and appraisal. And then, you know, it's going to be that much time. Then you're going to get a court hearing that's, again, 6 months out. It just delays everything. So do a double check, verify, make sure your totals are proper before you filed it. If you filed it, you go to do your accounting and you go, oh, dang it, I made a mistake. Oh, I'll just wait. Don't wait. Do a corrected one, correct your totals here, turn this in, then go to your accounting portion and everything should be good. Now, is there any more questions? Because I am done and ready to hand this off to Rex. Is there any questions on the inventory and appraisal form or the two attachments? Wow, y'all are good this morning. Okay, I'm ready for Rex if he wants to see where he is in the office, and I'll have him come in and he'll go over the accounting portion, and then I will come back and I will tell you how to fill out the petition for the approval of the accounting, and we'll just continue on. So hold on 1 second for me. Okay, I hear from my office. Here he is. You're on.
Okay, we continue on. Let me find my note paper. What we're going to cover next is the GC 400, which and we'll come back. Tamara will be back to go over the report that goes with the accounting when you turn it into the court. But she covered the initial forms, inventory and appraisal, and I'm going to pick it up from that point. So what we have here, so you can find out where we are, on the bottom of the page, lower left, are 4 digits and a number. In this case, we're on page 21. However, on my PDF slides, it says page 23, but you have to see it where it's written there as page 21. Now, this form, we always refer to it as the GC 400 sum. in the upper left. I don't use the 405 for anything in terms of referencing. Before we get into the details, if you're using this form and you happen to be not doing a guardianship or conservatorship, if you're doing a probate, you would list that, or if you are listing a trust, you would just write it in this top section and of course put your case number. Some other page formatting information before we get into the detail. This says summary of account, GC 400 sum, standard and simplified accounts, and it says for probate, guardianships, conservatorships. It's a required form. So you'll see in the lower left, it says adopted for mandatory use. Judicial council, which is kind of like the board of directors under the California Supreme Court. And then the form number, it's also required for trusts when they're reporting to the court. In the lower right, we have a reference. I call it a breadcrumb trail. And if you have questions about the form, you know, what law did this form evolve from? It shows here Probate Code section 1060. And then we've got the California Rules of Court 7.575. So if you have a question on something and you are like to look things up and maybe find a little bit more information, you can go to those code sections and determine perhaps how this form was designed. Another statement here, it says summary of account for standard or simplified accounts. Today, we are only going to be talking about standard accounts. I don't do the simplified accounts, and I'll just explain or define what they are. If you have a small accounting report, let's say you have a ward, a minor or a guardian, a conservatee, that has very few transactions during the year, and you can do the report in less than 5 pages, you can do what's called a simplified account, which instead of going through all the details that I'm going to explain, the simplified account looks more like a pocket check register. It's a sequential list of all transactions, income and disbursements in a chronological manner without breaking it out into categories. I personally don't use them. If you have a situation where you have very few transactions, you might consider it, but we're not going to be covering that today. Okay. So in the heading, we have summary of account. Fine. It's, in this case, it's the first account. So the way that the day you're appointed, you get your letters for testamentary or guardianship or conservator appointment. You have 90 days to file your inventory and appraisal. And then at the end of the first year, you will be required to submit your first account. And that's why this one says first. And if it's interim here, if you pick up an accounting that someone else has been doing for a number of years, say the change of trustee, for example, or change of executor or guardian, then you could start the numbers over so it's not confusing who was the one submitting this account. So it could be after the 6th account, you do first account for new trustee Jones. And the opening date, you'll see it's the same as we were using on the inventory and appraisal, the date you're appointed. And then it goes to the day before within 1 year of, after 1 year has passed. So that's the time frame, and you need to reconcile to that point. We start off with terms. In court accounting, as you know, law oftentimes is convoluted and use arcane language. It's kind of like Old English or something. And it's no exception here. That we have two sets of terms we're going to be using: charges and credits. Well, as a CPA and attorney, that to me, it should be debits and credits, but it's not. It's really not connected to that whole system at all. The term charges relates to what you're charged with. What's your responsibility? What is the court going to follow up and see what you have done with the funds? So the term charges might also be translated to responsibility. And then when you discharge your obligations properly and things are dispersed appropriately for the ward or the estate, then you get credits and you're discharged from responsibility. And the simple way of, another way to define it would be charges would be mostly income. So beginning in assets and income. But to me, it's a bit of a confusing term. So we start out with the property at hand at the beginning of the accounting period. We will be transferring the numbers from the inventory and appraisal verbatim. This one that you had prepared for the cash accounts, and then the other balance that we obtained from the probate referee. There's a term that shows up here called carry value. It's a term that's used a lot in court accounting, in income tax and normal business accounting. It would be called basis, but here it's called carry value. And it is the value as of the date of your appointment, as indicated on the second attachment on the inventory and appraisal. Another way that I describe carry value is that is the burden that you are carrying and you're responsible for. And you will have a list of assets on the inventory and appraisal that will follow all the subsequent years. And I also recommend that on your inventory and appraisal, your list of assets, you've indicated an asset number for each asset. And as you go through the accounting through the years, do not change the asset number in the future. So if in the future you sold asset number 5, don't reuse that number 5, just leave it out. Because in order for the probate examiners to be able to compare year after year, you want to make it easier for them that the asset number never changes over time. Okay, so we're starting out this on March 8th, 2012, and property on hand at the beginning of the period. I just thought of another, in this required form for guardianships, probate, conservators, and trusts, it is adopted for mandatory use. I do see some probate examiners allowing just a spreadsheet as the GC 400 sum, but I wouldn't use it even if you're doing your accounting on the computer, Excel, or some other software. I would recommend that you still transfer the numbers before you turn it into the court to the actual GC 400 sum, because it is required by law. So we have some detailed schedules. And the way I look at these, they're kind of like links on a website, that there may be receipts during a period. There may be links to 5, 6, 7, 8 different schedules for A, 3 or 4 schedules for B, but this is the total of all of them under that label of that schedule. So we're going to be going through how these numbers were developed. And a critical part of the court accounting is balancing. So we have beginning assets, everything that came in, came up with a total. Okay, then we have everything that went out, and we go back to what's on hand at the end. And these two numbers have to match. If they don't, your accounting will not be processed by the court. So, and when you add schedules, I would use numbers instead of using the letters that show here, like the next one, you know, CD. The reason why is I made the mistake of doing that at first, and you'll find that Schedule E is down here. So by switching to the numbers, Schedule 1, Schedule 2, Schedule 3, you avoid that potential conflict. Another minor item is this asterisk by depth charges and credits. When you look at that footnote, it says you have to put a 0 on every line that's empty. So you don't confuse the court that you forgot it. You're making an assertive statement that it is in fact 0. So we end up, we're going to go through the details of the amount of money received, amount of gain on sales. Then we will go through disbursements in the subschedules and losses. And then we'll go through the forms on the cash at the end of the account period and non-cash at the end of the account period. And as I mentioned, if you don't balance, you're not done. Don't even bother turning it in. It'll never get processed. So if you want to mark your book here in on this page 21 somehow, or some way on the computer screen, because what we're going to be doing in the rest of my presentation here is going back and forth between subschedules that are reflected here, and then we're going to come back to see how it looks on the GC 400 sum. It's kind of like a bicycle wheel, and this is the axle in the middle of it for the accounting. All the other schedules that we're going to be looking at come back to the GC 400 sum. So we're going to leave page 21 and we'll move over here to page, well, it says 21 1A because I added it later. Okay, so what we're going to do now is we're going to start going through the details of cash assets at the beginning of the period. Guess what? It's the same thing as your inventory and appraisal. It's just a copy job. It's the same data, format's the same, case number and all that. So there's not much to it, but it does need to match your inventory and appraisal. Then the next form after that, moving down the page, is the non-cash. And here again, we are working from the inventory and appraisal. And you'll see how the form is set up. These are non-cash assets at the beginning of the account. The account period. And so we have a description of the asset. And remember what I said about the asset numbers, keep consistent asset numbers, never change them. And then after description, what's the estimated market value of that asset? Well, if this is your first account, it's redundant because the inventory and appraisal was the market value. So this column with an asterisk says you don't need the market value on your first account. You just leave that blank, and then you bring over the carry value on your first account at the beginning of the period from your inventory and appraisal. There again, it's a copy job. And it just restates the inventory and appraisal that you submitted to the court 9 months earlier after 90 days of your appointment. And you indicate the totals. I'm switching back to the page 21. It matches on the first line 1A and 1B. Okay, so I'm gonna move a few pages down to page 22. And this is a summary sheet. We're going to be looking at many detailed schedules underneath these, kind of like links on a website. And these are summary. Let's say for interest income, we might have 7 pages of interest income. And then this form would be an accumulation of all of the income that came in on interest income. It does say optional worksheet, don't file with your accounting. I've never heard of anybody getting shot for turning it in. But I like this form because if I'm reviewing someone's accounting and I've got 7 pages of interest and the footers on the page are not cumulative, so it's not that easy to determine that the numbers were brought forward correctly. So I tend to like this form to use. Another just a issue for doing accounting for conservatorships. In some cases, you have one spouse being a conservatee and the other spouse is the guardian or conservator. Okay, if that occurs and all of their assets are community property, I've seen cases where attorneys in the court want the other spouse in the community property to do an accounting to the court. And it is not required. If all the assets in a conservatorship are community property, the well spouse, the cognizant spouse, does not have to do an accounting to the court because each party on a community property has full access of management. And my reference on that is Probate Code section 3051, 54, 55, and 88. So just keep that in mind. If you end up with that predicament, it needs to be changed because it's unfair to have the cognizant spouse have to do all that record keeping for community property that they in fact own half of. So we'll move on to the next page 23. We'll get into the subschedules. We're on receipts. So when we do receipts, income, you notice it's not called income like you would for tax. And as a side reference, a lot of court accounting ends up being used for tax. But the two systems are completely different assumptions. So you end up not being able to transfer things directly onto a tax return, for example, a fiduciary income tax return for a probate or a irrevocable trust. Everything, you need to adjust it because of the different assumptions. So in the reporting dividends, what you do is you get the broker statement for the investments, and you have to list every dividend statement, every item that was received. It's kind of redundant, it's on the statements, but guess what? You still have to enter every particular transactions. You cannot group like a quarterly statement and say, for this quarter, we received 1,200 of dividends. It won't be accepted. And I would also list it by security rather than sequential is what they're asking for. Then at the bottom of this, these are called judicial counsel forms. You indicate here that this is a subtotal because we're going to be going on to other income items. And we're also alerting the reader that we're on Schedule 1, which is an income schedule. And we have Schedule 1, and we're going to go through 6 pages before we're done with the income schedules. And when we get done with all of the, in this case, the income schedules for dividends, for example, we would bring it forward to the summary. We'll go on to page 24. And here we have receipts of interest income. Same drill, take the statement from the vendor, the bank, and list all the interest payments. The last 4 digits of the account number, like Tamara had mentioned, and you just have to list them item by item as you go through. And now we're a subtotal. It's not cumulative, so each page is subtotaled. It's not an accumulation of the prior page. If you do that, you'll never balance. And now we're on page 2 of 6 in the income section. And we move into another income subject category. And in this case, well, let me back up for a second in terms of dividends. I want to mention something here on dividends. And that is, there's a common procedure used on stock brokerage accounts called a dividend reinvestment program. Its initials are DRIP, Dividend Reinvestment Program. And if you have a large portfolio of securities and you're doing court accounting, the DRIP accounting where you're reinvesting will drive you nuts, because every dividend gets reinvested into more securities. So what that would require you to do is report the dividend as income. And then you have to put the dividend was purchasing new shares. So you have to add that as if you were buying new stock and carry that on your asset list. So it becomes very burdensome and tedious if you have a dividend reimbursement plan. So my suggestion is, if you have a situation like that, have the broker stop the reinvestment of dividends and just take the dividends and put them into cash. That will simplify your accounting. In terms of the schedules we're going to be going over today in income and disbursements, we're not going to cover them all, but there are more schedules. In fact, there are 48 different types of court accounting schedules on the Judicial Council and Court's website, which is a lot. And we're only going to be covering the most common. We're on pensions. Okay, so now we're on page 25. And we're handling pensions. You just list every one of the items. And another thing that's kind of a item for me, I guess you would call it a pet peeve or something else, is 6-digit dates. I think people, when they're in high school, the teachers teach 4-digit dates, and kids grow up and they're always using 4-digit dates. And it causes problems. For example, I had an IRS audit with a gentleman who was a salesman, and the auditor for IRS wanted to look at all his travel and entertainment expenses and meals. And he brought in a large stack of receipts from restaurants. All of those receipts were 4-digit dates. And it created a problem because you couldn't tell if this was for the current year under audit, or whether it was a prior year, or it was just a collection of 10 years. So what I suggest people do when they're doing any kind of record keeping is just get in the habit of using a 6-digit date, and then you'll never have that kind of problem. Okay, so we have a subtotal here of pensions, and we're on 3 of 6 in pages. Then we'll move on to rents on page 26. And when you have rental properties, you would end up having your rent separated by properties. So you can tell which property it came from. This schedule is for rents, and don't confuse it with other types of income. For example, if you have what's more like a business, say there's an Airbnb, a bed and breakfast, you would not list that here. This is for passive income. If you have a business, we'll cover that in the other lines on the GC 400. But I would also describe the property in terms of what type of property is it? Single family residence, 20-unit apartment building, a commercial building, so that the reader gets a better idea of what they're looking at. And we're on page 4 of 6 in the income section. So we'll go to page 27. Now we're looking at receipts. We had pensions before. Now we include the Social Security. And a couple things here. First of all, one of our students one time was a probate examiner from the court, and she noticed right off this error in the left column. And that error is you cannot take 3 months and add them together. You have to list every transaction. And so this would not be acceptable. Another item back when we were talking about real estate, we saw one situation where the person doing the court accounting had several rental properties, and they did a beautiful spreadsheet showing the rental income, the rental expenses by category in columns, and it was turned in landscape view, not portrait view. And it basically followed the Schedule E on a tax return, where you have you're reporting rental income and expenses by categories. It was completely rejected by the court. First of all, they won't accept any court accounting in landscape format. Secondarily, the court doesn't care about the income and expenses by category and the net income from each property. It's completely ignored. You have to follow the court type of format or they're going to kick it out. And another thing that you should use is at least a 12-point font when you're doing the court accounting. If you get them too small or too large, they'll be rejected. The next thing I want to cover is what I call netting, N-E-T, netting. And in the area of netting, net of the Medicare. So in this example, this is appropriate that the Social Security that we're going to be reporting here is the amount that actually came into the accounts. So it happened to have already 104 taken out for Medicare. And that's appropriate because you're only responsible for the money that comes in, not what could have come in. And so that's appropriate. It's way different than this other example or definition in terms of netting that you should never do. Let's say there's a rental property and the rent's supposed to be $3,000 a month. And the tenant is a carpenter and they say, well, I'll fix the porch for $500. And then you just show the rental income at $2,500. That is netting and that is not allowed, not appropriate. You would need to show the full amount of the rent that should have been charged and then an expense or disbursement for the amount of allocated to the repair of the porch. Okay, so I'll go to page 28. Receipts. This one, you can call it just miscellaneous. So all the accounts that we've had income before, anything else that's left over, just throw it here. Tax refunds, health insurance refunds, miscellaneous type items. Okay, so now this is also a subtotal. It's not accumulated from a prior page. And now it says we're on page 6 of 6 in the A series of forms. So now if we go back to page 22, this is the summary sheet. So what I would do here is add up the separate schedules for dividends, for interest, for rents, and accumulate them here to show the detail before bringing it back to page 21, which is the GC 400 sum. And with all those schedules we went through just now, it only ends up being 2 lines on the GC 400 sum, the summary page. So with all that detail, and now we've come through and we had beginning assets plus all receipts, so total charges. We're halfway done with the forms in terms of the accounting. So let me find my place here. Where he did rents. I don't have all these pages memorized, if you give me a moment. Gains on sales. Okay, so gains on sales, the way this works is, to me, counterintuitive, being a tax person. We have property sold, we had a residence, carry value, date of death, or date of appraisal if it was date of appointment. And so we show our carry value and then we show a sale price. And in this example, sold for $250,000 and it shows that there's a gain of 19,100. Well, to me, that is not the gain, and what they're calling gain, from my view, is completely irrelevant because there were closing costs. But notwithstanding my view, this is the way you have to report it, as carry value compared to sale price and gain, period. And we'll show you later where the cost of sale will end up in the expenses. There was a question in the chat about out-of-state real estate, and out-of-state property is not part of your court accounting because it's outside the jurisdiction of California. And the way I would report that is in the back of the accounting report, I'd put footnotes and then put a description of the out-of-state real property that you're ignoring in this accounting. So we'll go to page 30. And we have the residential costs for the conservatee. And here you just list the items every month as the cost. Generally, we're seeing now for skilled nursing facilities at about $6,000 a month. We had one client that ended up paying $150,000 for 1 year. One thing that happens that I noticed, because I do tax, is that when somebody has that much of skilled nursing facility because they can't care for themselves, it creates a huge medical expense. And from that point forward, the ward does not pay any income tax at all because of the huge living costs that end up being considered medical expenses. And in this case, I would use the cost of the rent and the lodging and things in these statements. They'll have other costs that I would show separately. Okay, so we'll go to page 31. We've got disbursements, general administrative. Here again, you can translate that to miscellaneous. We have reimbursement, we have attorney's fees, probate referee, disbursements. One thing about fees for attorneys and for executors and conservators, you can't pay for the conservator's fee or the executor's fee or anything until it's approved by the court. So you have to wait until the end of the year or the end of 2 years before any of that compensation can be paid. However, this is different in that the attorney's fees are reimbursements for monies that the attorney advanced to the estate, and they were getting reimbursed. This does not represent compensation. So, and we have the appraisal, the appraiser, probate referee's fee, and cost for the bond. This is just our miscellaneous. Then we'll go to page 32. And we have, this is separate from the rent type expense. This is miscellaneous living expenses, clothes, telephone, birthday gifts, things of that nature, personal items that are relevant and necessary for the ward during that account period. So we'll go on to page 33. We have medical expenses that are just listed, and this would be the instead of the total cost to the medical service provider, it would be the amount of out-of-pocket So if there's other amounts that the insurance company is paying, it's not going to show up on your accounting. And when I first looked at this, I couldn't understand. I understand check numbers, but I couldn't see 010T. And I was puzzling over that for a long time. And then I concluded it was probably because it was a temporary check. And that's why it was out of sequence, but I don't know for sure. I'll go to page 34. Okay, disbursements, we're on Schedule C now. Property sale expenses. I mentioned before about selling the real property and we had no closing costs. Now we have to show all those in detail and how much the escrow cost. One of the things people do in court accounting on real estate transactions, that every item on a seller's escrow statement gets reported in the court account. However, there's one number that's not, and that is the net amount of cash. Out of all the closing statements, that's the one item that doesn't get reported here. Another item when you're working with escrows, they call them closing statements. The clients always bring in what's called an estimated closing statement, because that's what's used all the way during the transaction. And then after the closing of escrow, usually the final closing escrow statement gets mailed to the seller. And that's the one you have to use for reporting, because you don't know on an estimated closing sheet statement whether there had been additional transactions changing that number. So just heads up on get the final closing statement. Okay, we'll go to page 35. Disbursements, sale of property, sale expense. In this example, we sold something on consignment and there was a commission paid. And so that was a disbursement there, selling furnishings. So we'll go to page 36. Now, it doesn't make any sense to me, but rental expenses are listed here sequentially. I would separate them out by properties, but list the loan amount, loan payment. You'll notice that there's no distinction between principal and interest. It's just boom, payment. And that's what's required. Here we have property tax, insurance. So separate out each of those by each separate property if you have more than one property. And we'll go to page 37. Disbursements, other expenses. This would be your miscellaneous again. Just list whatever didn't fit into a previous category. Some other things that may come up during your court accounting, and that is the guardian or conservator is also required to do tax returns for the ward, or for the probate estate, or for an irrevocable trust. And so the fiduciary ends up doing a tax return on the IRS form 1041 for probate estates. But when you're handling someone else's money in the tax environment, there's an IRS form 56 that you give IRS notice that a fiduciary is in charge of the finances and the tax returns. And the way that you would end up signing a tax return as a conservator would be, you would sign the individual's name, the ward, and then you would put by, And then you would write out your name, comma, conservator. And that's the acceptable way to do that with an income tax return. Another item just in terms of procedures to reduce headaches, and that is, I grew up in accounting and tax where we always ran adding machine tapes to verify your numbers. Well, you can hardly even find an adding machine anymore because everything's computerized. But notwithstanding that, what I suggest you do whenever you're adding up numbers for a court accounting is you compare what you keyed in with what the total is, because if you get a typo in your total, it takes so long to unwind an imbalance in court accounting. It's well worth it to get into the habit of verifying all of your input numbers. Okay, we'll go to page 38. Here we sold a car and it had a carry value, sale price, and a gain. And now that asset number will no longer be used on the beginning and ending inventory and appraisal. I wanted to point out, I had some notes from probate examiners on things that they thought were important. And one of which is, if you have some unusual expense, like you bought 20 sets of bed sheets. Well, that sounds a little excessive, but you might explain that the ward was incontinent. Or if you had bought a hot tub and had it installed at the house, it wasn't for the guardian's use and entertainment. You would describe the medical condition of the ward so that the expense is not flagged. Some other accounting errors or no-nos is reporting on assets that the fiduciary has no responsibility. So you get income in from some other source, it really isn't the under your purview, so you would leave it out. Another problem is confusing responsibility or carry value with real value or market value. Sometimes we'll see accounting receipts from assets that are not even identified in the accounting. Another thing that court examiners are looking for is if you have an entry and adjustment, we call it a fudge factor, to make the accounting balance. You didn't know how to find it, so you just put a number in. That's not allowed. Another problem is reporting assets on a net value. So if you have a house that is worth 1.5 million and it has a loan of 500,000, then they put a net value of 1 million for the value, and that's incorrect. Another problem with the court accounting is the fiduciaries writing checks to themselves. And the fiduciaries paying themselves before any beneficiaries are paid. When I had mentioned that this book came from the Conservators Handbook, and it's a good source of information if you want to look up something. I wanted to give you another reference citation, and when you get into problems and you're trying to figure out something in court accounting and it's beyond what makes sense to you or what your resources show, I wanted to point out that there's a book put out by Continuing Education of the Bar. It's called the Fiduciary Accounting Handbook. And it was written by a local attorney, Margaret Hand, with the help of a probate Commissioner Edward Green and Heather Hamilton, who is a professional fiduciary accounting person. And it's a good reference book. It's published by Continuing Education of the Bar. Last time I checked, it was about $240. And it is a good reference. Don't plan on reading it. Don't plan on learning court accounting by reading this thing. It's way too thick. But you can look up all kinds of transactions in order to be able to have authority for your position. Okay, we're on 38. I'm trying to catch up with myself here. If you give me a moment. Page 37. Let's go back here for a second. Okay, in the miscellaneous expenses, there's other things that would be indicated here. A court-approved allowance for the ward, housing repairs, recreation and leisure, bank and financial expenses, postage, pet expenses. We saw a situation where the decedent's estate had a horse, and that becomes a problem because of the maintenance and costs and everything. And the executor sold the horse right away to not burden the administration with the animal cost. But you get some unusual situations from time to time. Okay. Now we're, before we get to the assets at the end of the account period, we are done with the disbursements section. So we've done a summary, the income coming in, and we've just hit the last of the expense losses or disbursements. So at this point, we're going to bring the summaries of all the disbursements forward to the page 22 and summarize them under the various disbursement categories, run a total, and then we're going to go back to page 21 and enter the disbursements that we've reported. And then what that does is it brings us up to the assets at the end of account period. And let me find where we were there. Okay, so now we end up doing it's equivalent to the ending inventory and appraisal. So we list the cash reconciled balances as of the end of the account period. And then we end up with the non-cash, and basically you take your beginning inventory and appraisal using the same asset numbers, and whatever assets you have left goes on the ending non-cash assets. So at this point, back on page 21, we have gone through the disbursements, the value of the assets or the carry value of the assets at the end of the account, add it all up, and ta-da, we happen to balance. It's good. It's not so good when you don't balance. So as I mentioned previously, if you do a spreadsheet for the CG 400, I would also add the actual judicial counsel form before you turn it in. And the other thing that you need to do is when you turn in your accounting, I think Tamara will cover this also, you need to turn in your original bank statements with your accounting to support your transactions. When we get to the end of the class, I just wanted to point out that we do offer completion certificates. If you desire one, send us an email and we will send you a completion certificate. It's not for MCLE, but it does prove that you've gone through the court accounting class. After you've done your court accounting and you've got it all balanced out, you're going to have another step, and that is you're going to have to turn it into the court. And in order to turn it into the court, you're going to have a petition that explains various aspects. And I'm going to let Tamara Brown here continue on with the petition for the court.
Do you want your coffee?
Yes.
Hi, y'all. I'm back. You guys still hanging in there?
Tamara, I have a quick question.
Of course, hon, go.
Yes, Rex was saying that we needed to include the bank statements as backup to support what we're putting into these documents. But if there's something like a sale of property, do we need to include escrow statements that indicate costs associated with the sale of the property? Because that would,
Yes, absolutely, hon. It has to be the final closing statement.
okay, as well as, okay, thank you.
But the only difference between okay, so bank statements, although we will get into that part when I get further down, bank statements must be originals, and that doesn't mean originally printed off the bank's website. That's not original. It must be the original copy, or if so I always tell people, especially with, I know it's a pain in the neck because everybody wants to do this online stuff and no paper and blah, blah, blah. That doesn't work for the court. So I always state, if you're doing, depending on if it's a conservatorship or a, even a guardianship and the decedent's estate, or you're an administrator, make sure that you go to the bank and you tell them you must have bank statements mailed to you every single month. Now, say for instance, I lost a statement. Oh my God. But say for instance, I lost a statement. You can easily go to the bank, ask them to print the statement, and then they do a little type of signature certifying kind of that they printed the statement and not you, and the courts will accept that also. Some courts, from what I see, are a little bit pickier than others, but I'm sure you see that with a lot of things. So like, I can tell you Contra Costa is extremely picky. But Alameda has been, because that's my area, so I'm mentioning those counties. Alameda has been a little bit less strict about that they're originals, but you know, with all the fraud and stuff going on, they just want to make sure. And the way, and I tell the people this every day. So people say, well, when I get a PDF from the bank, I can't change it. And I'll tell you, I can change a PDF pretty easily, no matter how secure it is. I can manipulate that to where you can't tell whether I've changed something on it or not. So, now, I'm not saying I do it, but I know I can. I've done some pretty creative correcting of a PDF. So the courts are only trying to make sure that it is original and there's been no funny changes to it. So, yeah.
Okay, thank you.
Okay, I'm going to go into the petition part. And I apologize, I've got to try and find it, and I'm seeing it now. I think we're there. So what's the last thing you need to do? And I'm going to try and speed it up so we can get through the class. So what's the last thing you need to do? And this is where you're at. So you did the inventory and appraisal, you filed that. Okay, so that's all taken care of. Now you took all the numbers from your inventory and appraisal and you put it on your accounting. So now you have an accounting. And accounting, as you can see, the forms, the GC 400 forms that Rex went through, you just can't file those with the court. You need to file them with some, because like, what do you want the court to do? You need to tell them. Although it seems pretty self-explanatory, it's really not with the court. So this is what your petition does at the end, and it does a few more things than just introducing your accounting. So we're going to go through the petition. It must be on what they call pleading paper, and that pleading paper or that just states, see those numbers alongside here, it must be on this type of paper. If you don't have that type of paper, you can search Google. Google's always my friend, but you can search Google and just type in pleading paper and you can get all, I mean, there's so many different places. So definitely download that and it will go into, it can be opened up like in a Word file. Definitely open that and make sure this is on pleading paper. It cannot be handwritten, it must be typed, and so you'll have a little work with doing that. But so you will get though with pleading paper, you will get a completely blank sheet. None of this will be filled in, so it's going to be all up to you to use the example or ask like an LDA to help you or type this part up for you. But I'm going to go through how you would complete it on your own. My example again shows the attorney that, remember, I was stating on the inventory and appraisal, it was already pre-filled. So instead of this information, you have to remember this information is all your information. So for instance, I put Tamara Brown, my business address is 3000 Citrus Circles, Suite 207. And then I go through, I'm listing my, my phone number, again, the email address. Instead of saying attorney for, I would just say Tamara Brown pro per. And somebody asked a question earlier, I think Rex answered. Pro per is PRO and then space PER. You can say pro se, PRO, and then space SE. And those are the two that are commonly used. Then you would need to skip a few lines. This is the name of the court. Again, you could take all this information off your inventory and appraisal. This is the case number. I typically, I mean, and this is just me being funky at wanting to format and make it look what I call pretty, but I would leave a space in between the case number and the title of the document. Over on this side, this example is a conservatorship. And remember when I was explaining in the inventory and appraisal how you can be conservator of just the person, you can be conservator of just the estate, or you can be the conservator of the person and the estate. Remember, this is of the person, make medical decisions, no medical information, anything to do with the person, give permission for them to get married, just anything to do with the person. Estate only means money. So when you control the person and you don't control them, that's a very bad word. When you're a conservator of the person, it's only of the person. That doesn't mean their estate. They're two different things. So this is person, this is money. So in this case, they're conservator of both. person and money. This is the conservatee. And we always like to state if she's known as somebody else. So this could have been the maiden name, this could have been the married name, and then she went back to the maiden name. Some people have a real name and their known as name is completely different than the real name. So we just usually state all of that. So sometimes when you're referring to the other person, referring to the person in the other name, it gets confusing. But okay, so we're going to state they are the conservatee. Now, most of the time when you have your accounting, you're ready for your petition, you don't know your hearing date yet, because you're not going to get a hearing date until you actually turn in this petition. So you will still write the words date of the hearing and leave it blank. When you turn this into the court with your accounting, they will handwrite your hearing date in here in this space. They will also put the time. Sometimes I'll put the department in if I already know it. Otherwise, they will write the department. I do not usually include the judicial officer, only because there's a lot of situations where this person might, or this judge might not be the one who hears the case, might not be the one who signs the order, might not be the one, say for instance, they're on vacation, they're out. If too many cases, your case, it wouldn't be transferred to somebody else, but there might be other situations where I just don't include this. But you can put judicial officer and leave it blank. If you know who the judge is that's hearing your case, you can put their name. And then if there is a pro tem that fills in for them for whatever reason, they'll cross it out. They'll write their name. Okay, let's get started. So what are you saying, or what am I putting in this information? You were putting one, you are the petitioner. You are David, so this is your name. You're going to put in parentheses, hereinafter, I'm going to refer to myself as the conservator. And then as the conservator of the estate of Tina Lowry, conservatee, I present to you for settlement and allowance this verified first account. Now remember, this might not be your first account. This might be your second account. So on a conservatorship, the accounting's due after the first year of appointment, and then it's due every 2 years after. For a decedent's estate, accounts only due one time. So it would be a first. For a minor, you could have an account due, I think it's the same as a conservator, except for if it's a blocked account. So the judge kind of will determine or say when the accounting's due, but I know it really depends. It might be due the first year, it might be due every 2 years, but I will tell you with a conservatorship, which is this example, the first one is due after 1 year. And then the second one after that is 2 years after that. So it may not be your first. If it's not your first, don't put first here, put second. And I didn't even go through the title. I'm so sorry. Okay, so what is the title of our document? It is our first account that's current in a report of our conservatorship. You want to petition the court to approve for settlement, saying everything I did, they approve, they accept. In this case, I had the approval of sale of depreciating property. You are never allowed to be paid until you petition the court. So this is the only time you can ask for payment for all of your services if you so choose. Some people, if it's their mom, if it's their sister, that, you know, they won't bill or choose to bill. So it's, you won't necessarily have to. If you're not going to bill the conservatee, or I have other cases where the conservatee just has no cash. They only have house property, and so you can't get any funds or any payment for your services if they don't have any cash. So in that case, you would not include the words you're not asking for. So anything in this title you're not asking for, don't use my example, but tailor it to what works for you. So again, if you're not asking for an allowance of fees, don't put that part in. This is also the only time and place where the if there's an attorney, or if you have an attorney, that the attorney can be paid. In this example, they're showing an attorney being paid. But then again, if you think about it, it's a weird example, because if an attorney was being paid, you wouldn't be completing this, the law firm would, and as part of their compensation. So I wouldn't be teaching you and also paying an attorney. So it's kind of silly as my example. Okay, let's go back down. I'm skipping back down. So what I'm telling the court is I'm presenting for settlement, and I kind of just copying this whole thing right here. I'm just repeating it. So I, as the petitioner, am respectfully asking the court, or telling the court first. First, I'm telling the court what happened during the period, and then you'll see where I ask for approval and what I want. Okay, so the appointment. Okay, keep in mind, so like I've had a couple people say to me, Tam, why do I have to put when I was appointed? They can look at their computer and they can see it themselves. Anytime you submit a court paper or court forms, whether it's a declaration or a form or whatever, your papers have to stand on their own. And what does that mean? That means that anybody, me, your gardener, your neighbor, it doesn't matter who that person is, can pick up your paper and know everything by reading your paper. And you're not saying, oh, if you want to know when I was appointed, go look at your computer. If you want to know, you know, how much money I indicated on my inventory and appraisal, go look at the inventory and appraisal. No, it's not the court's job to go search through all your papers to find this stuff. You are actually indicating so that a judge can read this and know everything about your case. Well, not everything, but know enough about your case that he can make a decision just reading this piece of paper. Okay, so that's how we're starting it off. The petitioner was appointed conservator of the person and of the state of the conservatee on that date. Remember this date on the inventory and appraisal. Okay. And letters were issued on the 14th. So why are the dates different? You had your hearing, let's say on March 8th, but you didn't have your letters ready or turned in yet, or the judge said, okay, here's your order. Now you can go get your letters, or here's your order and I need a bond. So then you run out and you go, how do I go get a bond? And this date is on a Friday. So by the time you fill out a bond application and your bond gets approved, and then you turn in your letters, it's Monday now. This is the reason why the dates, but you're still responsible on the day you had the court hearing and the judge ordered the conservatorship. Okay, I am stating at all times since the appointment, I have been acting as the conservator. Nobody else has taken my place. And when would that be the case? Well, basically, if it's a court hearing, really nobody else could take the place. But let's say you had a bad accident and something happened, and so one of your kids were helping take care of grandma because you were in a hospital and you were there for 2 or 3 months. Well, during that time, you were not acting as the conservator because you really weren't. You would really have to state that, but there would be other things that you would have to do also because really nobody else is allowed to take care of the conservatee. And so there's other things that would happen. But anyway, you will state at all times you've been acting as conservatee. The next thing is my inventory and appraisal has been turned in. It was filed with the court on what date, and it showed what value. So now the judge automatically knows, okay, I can look at an inventory and appraisal and I'm going to see my starting cash or my total cash was this. I can look at this petition and see my total cash was this. I can look at the accounting and my total cash at the beginning is going to be this number. So all three numbers tie. Okay, slide down, number 3, the period of the account. You're going to tell the judge what the account period is. So this account period starts March 8th, the day I was ordered conservator. And it goes through an entire year, March 7th, 2013. Okay, charges and credits. Remember this word, charges and credits. I know crazy words, but Rex did explain them on the accounting. What is the difference between the charges and the credits? So you're stating here, the conservator is charged and is entitled to the credits. See my summary of account, which also has supporting schedules. And they should be incorporated into this petition. So basically a petition is something that kind of directs the court or asks the court. And so you're saying, please attach and accept the accounting as part of this petition. That's all you're stating. Okay, we're going to go down to authorized investments. Not sure if he told you, but you must remember that, and even if they weren't the same, so say for instance, you become a conservator, you find out the conservatee already had a bank. Now that you are in charge, you will make sure that the bank account is interest bearing. If it's not, you may wish to change that and make it interest bearing. And because you will see that a little later and why that's important. So all cash has been invested and maintained in interest bearing accounts. Let me tell you, I've had or seen a few cases in the past, mostly the decedent's estate. And so why the administrator is working on getting all the assets so they can get them in a distributable way, that the money was not an interest-bearing account. And when you're talking like this estate maybe had about $500,000. And so if you have an estate that has $500,000 and it's in an account that is not in an interest-bearing account, you can imagine on a monthly basis, let me just guess, say, I don't even know, $30, okay, $30 a month, times that by 12, and then times that by 2 or 3 years. It could be a lot of money, especially if my $30 is low. Anyway, So what happened is I had a case where the beneficiaries actually sued the conservator, or no, I'm sorry, the administrator of the estate for the interest that was lost by the administrator not putting the funds in an interest-bearing account. So see that amount, you say, oh, well, that amount might be $1,500 for the time period. Well, that's $1,500 that's coming out of your pocket just because you didn't put it in an interest-bearing account. Now, you also say, well, why would it come from me? Well, it was your job to put it in this interest-bearing account, and your job to manage the asset, and so it's your responsibility. It doesn't have to happen often, but I've seen it happen. So statements of liabilities incorporated in this petition is all the statements of all the liabilities of the state that are a lien against the assets. I put in here there are no taxes due or unpaid, no outstanding judgments that the state is liable for. Now, number 7 only, well, there's a few of them, but I'm going to name the numbers because I've said this before in previous talks that we've done. I've said, well, if you don't have a sale of automobile, of course, you're not going to put it here. You're going to skip it. If you don't have a sale of furniture, then you're going to not put it there. Well, I said that, and I said, whatever you don't have, just skip it. Don't put it on the petition. And I was reviewing a few accountings that got rejected, and so they came to me to review and help them correct them so that they can get it turned in. And they went from like number 5 and then went down to number 10 and forgot some really, or let's say they even skipped that and went down to number 11 and forgot some really important information. And they said, well, it didn't pertain to me. And I said, oh, yes, it did. And that's why it got rejected. So I'm going to specifically state number 7, which is a sale of an automobile. If you don't sell an automobile, you will not put this in here. You don't put sale of automobile, none. You just wouldn't put anything in here. You'd skip this. Your number 7 might be the words of number 8 or something like that. So in this case, or the example, which Rick showed in the accounting, the conservatee sold an automobile. I would put, it was on the inventory and appraisal. It was on attachment 2. And it was item number 7. So let's just quickly go back to attachment 2 so you can see. Although I don't think I have an automobile on here. I don't. Anyway, here's attachment 2. It would have been item number 7. And it would have said, I don't know, Mercedes 3250, whatever car, and it would have had a value here. Okay, I'm gonna swing back. I think it's here. So in this case, I sold the item for a loss. What does that mean? The inventory and appraisal was completed by the probate referee. Say the probate referee valued that Mercedes for $5,000, but you couldn't sell it for $5,000 because, I don't know, maybe somebody cracked the back window, or maybe, which the probate referee wouldn't have known, there was no alternator or something with the car, and you sold it for a loss. You're not only saying, okay, it was on the inventory and appraisal, I sold it for a loss, I showed it on Schedule D of my accounting, and you as a conservator just want the court to confirm and approve that the sale of that property was okay. Now, you may think, why do I have to ask for them? Okay. So say you don't ask for the approval or that to be approved or something like that. Later on, and let's say this goes for your, and I'm talking more a decedent's estate. You go on for a little while and you haven't distributed yet. And then maybe a year goes by and you're ready to distribute. And one of the beneficiaries go, wait a minute, where's the Mercedes? And you go, well, I sold it. And they go, okay, well, how much did you sell it for? Well, I sold it for $2,500. Well, wait, the probate referee said it was worth $5,000. No, why'd you sell it for so cheap? I want $5,000. And you go, but it wasn't worth blah, blah, blah. When you have a court confirm an action you took, no beneficiary can come back and possibly charge you for it later. Once the court signs this and confirms your sale of that automobile, it's done. Sorry for the loss of the beneficiary, even if he is right or she is right. The court has approved it. They understood what you did. They knew why you did it. They approved it. So that's the importance of getting the court to approve stuff that you've done. Okay, sale of furniture and fixtures, same kind of thing. In this case, there was furniture and they sold the Conservators beach home, which, you know, who cares? We know she's never going to go back to that home. So they've just indicated, see, the level of care she's under at this point indicates they will never return to that home. So there was no use for the furniture. So this is how we state. We sold the items. There was numerous items. They were not considered valuable enough for an auction. I don't typically put that, but I could see where it would be a good thing. In this one, they said it was, they went to a consignment place similar to a yard or a garage sale. Perfect. This property was sold for its appraised value. So say for instance, again, remember it was on the inventory and appraisal. You've already stated that. What was the value? They sold it for the same price that probate referee valued, except for they're stating here, I had to pay a dealer 20% of the amount of what was sold. And so you're just continuing on saying that information. Number 9, I sold the real property. Conservator sold the vacation home. It's shown on schedule, you know, B. The court confirmed it. Additional bond. Okay. Additional bond at the time of the sale of the vacation home. And this is explaining to the court. Now I sold the vacation home. So the vacation, I used to only have 50,500. I sold the vacation home for 183,418. I think I need to increase my bond because now I have cash of $184,000. My bond is $20,000, and oops, it's not even sufficient. Most of the time, instead of me going ahead and getting the additional bond and so on and so forth, I wait for the court to, at the hearing, to say, hey, by the way, your bond is too low and you need to increase your bond. Okay, but one very, 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 very important thing that you must, and I can't say this enough, your entire petition, accounting, and everything will be rejected if you don't have this in. No affiliate relationship. During the account period, the conservator has not hired an agent who is a family member or an affiliate relationship with the conservator. Let me explain the reason for that real quick. So I use the same one in every talk, and I know I'm need about 15 more minutes. So say for instance, conservatee, remember she has a residence, but maybe she's not living at the residence. Maybe she's come to live at my house a little bit, but because her house is in, let's just say an HOA, the yard work has to be kept up. So the conservatee has always had a gardener. She pays the gardener $50 every week, and so on and so forth. That's perfect. Now, the gardener says, I'm going on vacation for 2 months. And so I won't be around. You're going to have to get somebody else. I'm going, oh, Jesus. Okay, let me quickly get somebody else. I try to get somebody, everybody's booked. I can't get anybody. Guess what? My son's home from school on summer break, and he needs a job, and he wants to make money for going to college on the next semester. So he says, well, shoot, I'll do it. And I say, okay. And I said, because, oh my God, you just, thankfully, you're so nice. And I know you need the money. And so how about I'll pay you $100 a week. Just get it done. And till the gardener comes back. So for 2 months, I'm paying my son $100 a week. And no big deal because the gardener's coming back soon. Does anybody see where there might be a tiny bit of a problem in that? Everybody's shy today. There would be a huge problem in that, and especially because of the fact that, one, my son is my family member, and that's not always just the bad thing. Two, I was going to pay my son $100 a week when I was only paying the gardener $50 a week. So I doubled my son's salary because it was my son. And if I would have hired a different gardener, I would have said, no, I can only pay you $50 a week, and it is what it is. Do you want the job? Now, if they were being too low and I just could not find another company for $50 a week, so I had to pay 60 or 70 because I just couldn't find anybody else, and they were not family related, it's okay. But if it's family related and I'm giving my family member a little bit more money than the average person, you have a problem, and you need to tell the courts, and you need to state it's not bad that you're hiring a family member. Again, if I put in here that I hired my son for 2 months at $15 an hour, the same rate the gardener was charging for the 2 months the gardener was on vacation, there's absolutely no problem whatsoever in that. It's perfectly fine. It's, they want to know if there was ever a time where you paid a family member, and then they're going to look to see if that was reasonable costs or you paid them a reasonable fee. If you did not, guess what's going to happen? You're going to pay back that difference. So I would have been responsible for at least $50 a week the entire time my son was mowing the lawn. I'd have to pay that amount back. Okay, got it? The person can be somebody who's my best friend that owns a different landscaping company. And I say, hey, I can get you a job for 2 months at paying more than you can get at your clients. So how about you do my client's yard work for 2 months instead of doing your clients? Nope, can't do it. Okay. Compensation, we're getting down to you asking for a compensation. In this case, now remember, this has been a year, and this conservator said, I've spent 150 hours, which I think is unheard of, but providing services to the conservatee who is this was written by the attorney, but I would say who is my mother. Me, myself, personally, I'd have a hard time ever charging my mother, so I wouldn't. 150 hours, he probably took her to a few doctor's appointments, but here's where he states what he did. So he visited his mother at the care facility once a week. To me, it seems kind of odd that I'm charging my mother to visit her once a week at a facility. That's just me, sorry. And made sure that she's receiving proper care and that all her personal needs are met. The conservator, me, has marshaled all of her assets. I paid all her bills promptly, and I managed her estate frugally. I arranged the sale of her automobile, which she could no longer drive. I listed the vacation home. I did all that I had to do. For those 150 hours, I want to be paid $500. Very low, but it's a reasonable amount to compensate me because I missed time from work to attend court hearings. Now, I will tell you there's a local court rule for every single county. You can go to the law library. You can look online for the local court rule for every single county. But I can tell you Contra Costa County, their local court rule, every time I get in this class, I forget what number it is, but their local court rule, you can look it up, but their local court rule, the hourly rate is $75. And that is for a non-professional fiduciary. Rex is looking while I'm talking here. 7.4, I got it, thank you, right here. It is 7.426. So it lists the rates that an attorney can charge, the fiduciary rate. So for a professional fiduciary, that's only if you have a license or if you hired one, is between 125 and 195. That's C. So number D is a non-professional fiduciary. It's $75 per hour. So say, for instance, I want to say I put in 150 hours. I could charge $75 an hour for those 150 hours. That's if she had the money in the bank. And the conservative, wasn't my mom, because I don't know if I could do that for my mom, but you are entitled to that amount of money. So what does that mean? That can mean you took her to doctor appointments, you took her to get her hair cut, her nails trimmed, maybe a spa day. You took her out because she said she wanted to go to, I don't know, visit a flower shop, or, go to an art class, or, anything like that. You can write all that down and you can be request reimbursement. Okay, in this case, remember it could be attorney compensation. So if you had to, in this case, this is the only time you can ask the attorney for to be paid by the conservator. So in this case, I'd say the conservator retained the services of an attorney, and the attorney wants this amount of money, and it's reasonable compensation for the services. Okay, this is a very important thing also to include on your petition is the veterans' benefits, whether they received any money from the Department of Veteran Affairs. It's important to state that. If they were in a state hospital, you would state that or not. Conservatee's address, I would only put this if it was a care facility. And especially I would definitely not put it if it was my home. Because I don't want people, I just wouldn't want it. Okay, account statements submitted to the court with but not attached. Why? So there is a separate cover page for bank statements. Banks, okay, so this petition is public. Anybody from the public can get a copy of it. When you submit original bank statements, under a cover sheet, they become confidential, which means they go into the court system and they're considered confidential. And so anybody off the street or even a party to the case could not go to the court and order a copy of those bank statements, confidential. And you can understand why. Okay, capital changes. I would indicate that here. Statement of liabilities, if I paid off, stating there were liabilities, there was a loan on that vacation home sold, we no longer have it. Special notice, just understand with any case, you can pay, anybody can pay $40, that's all it is, to file a request for special notice on your case. So that means if I wanted to know how good or how bad you are caring for your mother, and I'm the neighbor, and I was concerned that, I don't know, you didn't, I don't know, you were not taking good care or you had bad intentions, and I wanted to just follow the case, I could pay $40 and do a request for special notice, which means every single time you file a court document, you must send me in the mail a copy of that document. Really, I'd want to say it's none of your dang business, but if they file for a special notice, you got to send them a copy. Okay, now what do you want the court to do? We're at the end. What do you want the court to do? Oh, Your Honor, I'm praying that you please just do this, that you approve and settle the account, which means no beneficiary can come back later and say, I did something wrong or charge me back. The acts of that I have performed, which means selling the car, selling the vacation home, selling the rental property, doing all that I did, are to be approved by you, Your Honor. That the sale of the Conservators automobile is approved, and I have stated that in there. Sorry, hold on one second. Sorry, that was my son saying he got out of school early. Anyway, the sale of the automobile is approved. The sale of the furniture, even though I had to pay a commission on it and lost a little bit on it. And the settlement of the account. So now I should be entitled to pay myself the $500 that you saw me request above as compensation for my services. And it's okay that I pay the attorney $3,500. And, Your Honor, anything else that you deem that I need to do that's proper. I'm going to date it, sign it. Oh, and the attorney, if there was one, you won't have this in that case. There is no attorney, so it's signed. One last thing. You have to, you must have a verification. The verification should state these exact words. That verification at the end says you declare under penalty of perjury that the foregoing is true and correct. You date it, you sign it, you turn it in. Here is an example of you would again take pleading paper. Here is an example of how you would submit your original bank statements. original bank statements, and then you would just put them behind. And that concludes our entire course for today. Does anybody have any questions, comments? Wish it was faster, wish it wasn't as so boring, wish it had different detailed information, wish it would have covered a section more, longer, more details, anything? Go ahead.
I have a question about objects. My
Honey, I
filed
think,
a petition, and
I'm sorry, your internet, so
Can
I'm
you hear me?
only hearing like one or two words.
So can you hear me now?
A little bit better,
Hello.
yes.
Okay. Wondering about filing objections. So I do that on the pleading paper. My brother filed a petition and asked for one of two things that both my dad's trust, which is the version he submitted. How do I ask for subpoenas within the objections to get the original copy of the trust from an attorney who's not being cooperative? And
Okay, hold on, honey. I'm gonna have to stop you. I'm gonna have to, I'll put our office number in the chat. I'm gonna have to have you call me because I'm really only hearing one of about 5 words you're saying. And I think it's your internet. So
okay.
I can't hear, I couldn't even get what you were asking for. I heard one word that said
That's okay.
trust. That's okay. And so if you call the office, I promise I'll answer whatever question it is. Anybody else?
Okay.
Everybody good? Well, that was easy. Okay. So you're free to go. And you know what I said? I put the number in the chat. I'm sorry. So I'll type it now. Oh, and if you send that off, will be here today. I'll be able to pick up and answer your question, hun. And if there's nobody else who has any other question, again, send an email to Rex and I can do a certificate if you wish to have it. And then if you wish to turn in any of the what did you call those statements? I guess that tells us evaluation statements. You can do that also to the email. Otherwise, you all are free to go. We will log off. Oh, and remember, if it was too much, too fast, or you want to know anything more, we repeat the class about every 2 months, sometimes 3. So we will be repeating the class. You're free to take it as many times as you.
All right, thank you very much.
Thank you.
Thank you for attending.
All right. Bye-bye.
Bye.
I thought it was good.
On the right, it says more. Stop recording.
It won't.